Hello friends, in this video, let's discuss about winding up of a company. Winding up of a company means termination of its legal existence. That means closing a company. So this is the process involves realizing the assets, settling the liabilities and distributing any remaining assets to shareholders. So I'll be deeply clearly explaining about closing up or winding up of a company. So in India, under the Companies Act 2013, winding up can be initiated either voluntarily, left-hand side I mentioned voluntarily, or by the voluntarily by the company's members or compulsory by the tribunal. So a company can be closed voluntarily. So someone, a director or a shareholder can request voluntarily closing up of the company, winding up of the company, or due to some misfortune, due to some fraudulent activities, court can or tribunal can order a company to wind up. Let's discuss about voluntarily winding up. So, as I already mentioned, this is initiated by members, can be solvent or insolvent. So, voluntary winding up occurs when members decide to cease the operations. So, the members of the company, they decided to stop operations from the company. So, this is again two. This is again divided into two types: members voluntarily winding up, creditors voluntarily winding up. So it is simple. When members wanted to wind up the company, they will initiate a process. If creditors wanted to wind up the company, same thing. So creditor plays a significant role in appointing the liquidator. So liquidator is a person who makes sure winding up is happening properly or not. Now, let's discuss about compulsory winding up. So, compulsory winding up, there are like some cases where compulsorily winding up is mandated. First of all, inability to pay debts. A company is not in a position to pay any debts. Then they can approach the tribunal. Tribunal will give compulsory winding up of the company. And fraudulent conduct or mismanagement. So in a company, these are the very important things. If a company is doing fraudulent conduct, mismanagement, non-compliance with the statutory obligations, acts against the sovereignty and integrity of India, court-ordered winding up. So in all these cases, a tribunal, law tribunal can order for a compulsory winding up. Now, let's talk about the procedural aspects. So, different procedures exist for winding up under various grounds. So, these things are defined in Section 271, defines in Section 271 of Indian Companies Act 2013. So, like Insolvency and Bankruptcy Code 2016, IBC is also there. So, these, as by following these two procedures, the company can be wound up. Now, impact on shareholders. So, legal grounds is completed. Impact on shareholders. So, stakeholders. So, whenever stakeholders are nothing but shareholders, creditors, employees, and management. So, when a company is going for a wind up, shareholders are the potential loss. They face potential loss of investment. Creditors claims will be settled according to the priority. For employees job will be lost, like they lose the jobs, employees. And management scrutiny will be there. Fraud or misconduct is alleged. So stakeholders, like uh, for any like if any company is processing for wind up, stakeholders are the persons who will get more impact. And finally, legal safeguards. So to do this, first of all, we start with the appointment of a liquidator. Liquidator is nothing but a qualified professional who oversee the entire process and priority of claims. So clear guidelines to protect creditors and employers. So once a liquidator is appointed, he will prioritize all the claims and provide, he will try to pay back the money to the creditors. And judicial oversights. So we have laws placed to ensure fairness and transparency. So with the conclusion, we can conclude that winding up of a company in India is governed by the comprehensive legal framework to ensure fairness and orderliness. Understanding these circumstances and legal intricacies is essential for effective corporate governance and compliance. So, thank you.